Good day, everybody. Thank you so much for joining me for the March 2021 webinars for rental agents. Thank you so much for allowing me the time to discuss all sorts of rental related matters with you. I am going to do something quite exciting today. We are talking about the Rental Housing Tribunal. Now, the reason I say that's exciting is not because I actually find it overly exciting to go to the tribunal. It's not a place that you would easily find most rental attorneys. We tend to be in court. Well, ideally in my life, I prefer to sort it out over a negotiation. But if you have to do something, more likely a court than a tribunal. But why I find it exciting is because as a rental attorney, I don't get a lot of exposure to the tribunal, but my clients as landlords, as well as you guys as the rental agents, very often run into situations where the tribunal becomes relevant. So I had to spend quite a lot of time researching the tribunal and really getting into details around the Rental Housing Act, the unfair practice regulations, and then the regulations pertaining to the tribunal to prepare for this webinar. So thank you for specifically asking me to deal with the Rental Housing Tribunal, because I think I've learned more than I have in quite a bit of time, because if you practice in the same practice area, it's not often that you see something spectacularly new and exciting. So thank you guys for letting me do some tribunal research. So I'm going to share everything I've learned with you guys. And luckily, because it's something that's pretty much written down, it's relatively easy to get all the ins and outs. I obviously, in 40 minutes, can't discuss every single element of the tribunal with you. But what I can do is I can tell you that everything from the tribunal, the way it functions, the type of matters we can take to the tribunal, the way the hearing will run, everything is either in the Rental Housing Act or in the unfair practice regulations dealing with the functioning of the tribunal. So on that very specific topic, you guys are more than welcome to visit our website, sslr.co.za, and download a copy of the unfair practice regulations. Please make sure you note that there are two sets of unfair practice regulations. The one deals with unfair practices, and the other one deals with the functioning of the tribunal. And then obviously the Rental Housing Act. If you struggle to get your hands on any one of these documents, please feel free to contact us. Obviously, more than happy to make sure you guys get a copy of the correct documentation. At the same time, unfair practice regulations are very province specific. So we have a general set of rules and regulations. These are the ones you can download from our website, but the specific provincial regulations, this you will find on the websites of the specific rental housing tribunals. So very important to keep that in mind. I do recommend, if you can, to maybe even pause the video or whatever the case might be, and just download a copy of the unfair practice regulations so you have it close to you and make some notes on it. Obviously, if you have time, otherwise just get it afterwards and go through it in a lot of detail. It's very exciting bedtime reading. So let's get into the actual things that I've learned over the past few days. So first of all, something very important to note about the Rental Housing Tribunal is that this is a creature of statute. What does this mean? It means that this body, this entity, derives all its powers, all its rights, and all its obligations from a piece of legislation, an act. In this specific case, the Rental Housing Act. More specifically, this sits in Chapter 4, being Section 6 all the way to Section 15 of the Rental Housing Act, the powers of the Rental Housing Tribunal and the way it should be set up. So the person responsible to set up the provincial tribunals, as well as create the procedural and unfair practice regulations, is the MEC in each province. So the MEC is the executive council in the specific province for housing issues. Why this is relevant is, if you know who the responsible person is per province, you know who to approach if you have a problem. If you have a problem on a provincial level that cannot be resolved, for instance, your tribunal doesn't issue regulations as they should in terms of the act, or they are acting out of the bounds of the act, or anything like that. The overseeing body responsible for the Rental Housing Act and all rental housing matters is the Department of Human Settlements. Obviously, with the Minister of Human Settlements overseeing the entire department. Once you know this and you understand that the tribunal is set up by the Act, it suddenly makes a lot of sense, because the Rental Housing Tribunal is not a court of law. It functions in some ways quite similar to a court, but it's not a court. It can only do things within the bounds of the Act and the regulations that stems from the Act. There's another forum that you guys are very well aware of, which is also a creature of statute. This is the Magistrates Court. So the Magistrates Court derives its power and existence from the Magistrates Courts Act. This is why very often we will advise to go to the High Court, because we will say the Magistrate Court doesn't have jurisdiction, or the Magistrate Court cannot rule on these kind of matters. And everybody thinks, but why? What? The High Court has inherent jurisdiction, and the High Court has a level of discretion. The Magistrate Court doesn't, and neither does the Rental Housing Tribunal. Their powers are limited to the acts and the regulations attached to it. So they don't have the discretion that the High Court has. Unfortunately, it does sometimes happen that the presiding officer or the chairperson from the tribunal might sort of, very usually accidentally so, overstep the bounds of the regulations or the Act. So it's important for you as an agent to know where those rights, where the boundaries of the rights lie, what they are, and where you can find them. And those are in the regulations. So if you have to go to the tribunal and you want to know exactly how it should function, it's all written down. And because the tribunal doesn't have any level of discretion to apply, you know exactly what to expect, and you will know when a decision wasn't considered in line with the regulations. So this is something quite handy and important to be aware of. The functioning of the Rental Housing Tribunal is very important. The purpose of the tribunal is exclusively, and listen to my word, exclusively, to deal with unfair practices in the context of the Rental Housing Act. The Rental Housing Act has regulations, unfair practice regulations attached to it. Very important to know these regulations, because there's a lot of things in there that would make your lives easier. For instance, Regulation 4, dealing with a situation where a tenant, for instance, doesn't sign a lease agreement and simply takes occupation of the premises, starts paying rent. 3 months later, you try to convince them to sign and they say, no, thank you. Regulation 4 says as soon as that happens, as soon as a tenant takes occupation and pays rent, or as soon as the landlord accepts rent and allows occupation, the lease agreement is deemed to have been concluded. Now, I don't want to bore you today with the content of the unfair practice regulations, but it's important for you to know them. Reason being, there are instances where it could be much quicker, much cheaper to approach the rental housing tribunal instead of going through an attorney through a court of law to, for instance, compel a tenant to sign a copy of the lease agreement. You can skip the entire thing if you know the unfair practice regulation. The tribunal does two things. On the one hand, mediation, and on the other hand, hearings. Mediation is when two parties struggle to find resolve in a matter, and all they need is an independent facilitator facilitating the conversation between them and allowing them to meet each other halfway. On the other hand, if that doesn't work, which let's be fair, very often doesn't, because a landlord and a tenant might be very far apart, and now you need to bring witnesses and expert witnesses and show evidence and lead oral evidence. In those cases, we're going to have to take the matter on a hearing. Very important. Your mediation is very calm, informal, nothing scary really. It's more a sit-down conversation to resolve the issue. The hearing element of the tribunal looks very much like a court, and the process is very similar to the process that you would have in a court. But what's important is the tribunal is not a court. This is very important because I very often, in training sessions I do like this in the comments section, it will pop up, or on the WhatsApp groups I have with rental agents, or whatever the case might be, I will answer a question for a rental agent. Very often, the comment I get is, still, no, you can't be right because the tribunal ruled something exactly opposite or very different from what you are saying. This happens, and I've seen it, unfortunately, quite a few times. Remember, the presiding officers, the chairperson in the tribunal chairing the hearing, is usually not an attorney or an advocate. It's very often somebody with quite a lot of experience in the property area, or even a lawyer, but not with a lot of experience necessarily in rentals and in the property property sector. So very often we do see that the application of the act and the application of the regulations might not be 100% correct when considering actual court cases. Why is this relevant? In courts and in law, we have a precedent system. The precedent system means a higher court, a ruling from a higher court, will bind lower courts. For instance, if the Constitutional Court rules on a matter, a high court or even the Supreme Court of Appeal cannot disregard that specific ruling. They may overturn it, they may change the interpretation, but they are bound by that particular thing unless there is a valid argument in law to disregard that particular matter in law. This is not the case in the tribunal. To be honest, this is not even the case in the magistrate's court. It doesn't create precedents. It might guide somebody, but it's not the law. If the tribunal rules on a matter in the Western Cape, you cannot use that ruling and bring it to Gauteng, or even again in a later matter, even in the Western Cape, and say you've ruled on this and you said, argument's sake, the tenant is responsible to repair the pool pump. So in other words, now everywhere, all the tribunals must give the same ruling. It doesn't work like that. It does in the courts, and especially the higher your court is, the more other courts are bound by your rulings. This is not the case in the case of the tribunal. The rulings from the tribunal does, however, carry the weight of a magistrate's court order. That means if you get a ruling from the tribunal, be that either through a mediation agreement that was made a ruling, or after a hearing the tribunal made a ruling, those circumstances, if the one party doesn't act in terms of that ruling, you may execute that through a magistrate's court. So, for instance, go to the tribunal to have a deposit repaid, and the court orders that the landlord must repay the deposit, to a portion of the deposit, whatever the case might be, to the tenant. The landlord then doesn't. The tenant can then approach the magistrate court in the jurisdiction, within the jurisdiction of that particular tribunal, and issue a warrant of execution like you would do on the back of a judgment. Please keep in mind the terminology I'm using here. Magistrate court, I'm saying judgment. Tribunal, I'm saying ruling. Your orders from the Rental Housing Tribunal is not a judgment. Even though it can be executed through a magistrate court, it's not a judgment as you would get in a court. It's very important to be aware of this. If you've been to the tribunal and you know that the ruling was made incorrect, it was not in line with the, say for instance, practice regulations they had to follow, something wasn't correct, something was completely incorrectly applied, you may approach a court for a review process. And I hope in some instances we would do this more often, because very often it's just not worth the money to be spent on that. But very often it is. And if you feel you've been ruled against unfairly, or something that wasn't just or equitable, or wasn't done procedurally correct in terms of the practice regulations, you may have the matter reviewed in a magistrate's court. The process, unfortunately, I would recommend that you do approach an attorney to do that for you, because now suddenly you go from a place where you can represent yourself, where you can still represent yourself in marriage court, but it's a very different way, and it's a very different, much less informal functioning in a court, but a court may review the rulings made by the tribunal. Who may lodge a complaint? A tenant, a landlord, a group of tenants or landlords, so groups of these people, or an interest group, or a representative on behalf of any one of these, on behalf of a tenant, a landlord, or a group of tenants, or a group of landlords. And that representative, however, must have written instruction from the complainant to lodge the particular complaint. I want to pause here because this is agent training. Can you see, nowhere here do we see the term rental agent, estate agent, agent, representative, but representative, I will show you later, is a person that has a specific instruction, and it cannot be the agent. The agent will only be involved in matters where the agent was guilty or is accused of unfair practices. Remember, rental agent, you are mandated on behalf of the landlord, but you are not the landlord. If the landlord does something, for instance, exploitative rentals, you market the property, you will know if it's an exploitative rental, but say it's in an area that you don't know, but it is your mandate to rent the property out at that particular rental. It's not you that is guilty of the unfair practice, it is the landlord. I would love to see that agents advise their landlords to stay away from unfair practices, but you as the agent in most circumstances won't actually be the accused party in front of the tribunal, yet you are. Very often, it's important for you to know that there's a lot of people that sees the Rental Housing Tribunal sort of in line with the EAAB, and they feel that if they feel wronged by the rental agent, they're going to take you to the tribunal. the tribunal can only rule on matters that relate to unfair practices exclusively in terms of the Rental Housing Act. The Rental Housing Act doesn't even refer to the rental agent. The Rental Housing Act deals with the relationship exclusively between the landlord and the tenant. If there's an issue with commission, with fulfillment of your mandate, with fulfillment of your duties as an agent, that is EAAB issues. It's not the tribunal. How do you respond to that? Because the tribunal doesn't have jurisdiction to deal with that, when that complaint lands and you receive it in your inbox, you simply reply and you say, I'm sorry, tribunal, this is not a you problem. The complaint is that my commission is too high. You don't have jurisdiction to deal with this particular complaint. This is exactly to my point. The matters that would constitute complaints that can go to the Rental Housing Tribunal are matters that come straight from the Rental Housing Act, the unfair practice regulations, or the administration around that. So unfair practices would be something like overcrowding, unacceptable living conditions, like I said, exploitative rentals, or lack of maintenance. Can you see that the agent can't really be involved in any of this? What we do have is urgent spoliation applications and urgent interdicts. And yeah, unfortunately, I have to say, sometimes the agents are involved in this, because sometimes the landlord puts a lot of pressure on the agent, or the agent feels responsible in a way for placing a tenant that is now not paying rent. And you, as the agent, on behalf of the landlord, go disconnect utility supply, take off the front door, telling everybody that you're doing maintenance. All of those things are illegal. And on an urgent basis, the tenant can go to the Rental Housing Tribunal to be ordered then to put them back in possession of the premises. If you as the agent get involved in unfair practices like that, yes, then you will end up in front of the tribunal, and we definitely do not want that for you. How do we lodge a complaint? It must be in writing, and this is in terms of Regulation 2.3 Annexure A. You will see if you download the documentation, all the annexes form part of the unfair practice regulations. Fun fact, this must be sent to the tribunal by fax or registered mail. Now, what gets me on this one is confirmation of transmission of a fax is proof of the tribunal's receipt of a complaint. Now, this blows my mind on a whole new level. It's the year 2021. I don't even know if anybody still has a fax machine. But what this means, and remember, this act is from 2008, fax machines were all the rage thing. You know that little report that you got, now I'm giving my age away, that little report you got when you faxed something, this is the report, this is the confirmation that your complaint was lodged. I would then rather go for hand delivery to the office of the Rental Housing Tribunal. Guys, remember, every province has its own Rental Housing Tribunal. You need to make sure that you get to the correct tribunal in your province, and my best way would then be get a stamped copy of lodgement of Annexure A in terms of Regulation 2.3, download the form, print it out, complete it, take it to the tribunal, and your stamped copy, actually definitely a better proof than a fax copy, because you're going to have to go and find your fax machine somewhere in a storeroom if you time travel and fetch him then. So this is something to be aware of. What does the process look like? So you may not ever, none of the parties, I said neither because I meant landlord or tenant, but now the groups and everybody else, you are not allowed to lodge a complaint with the tribunal if there is a pending process in a court. This is a rule in courts as well. This is called, this is actually a defense that you can raise Say, for instance, I issue summons in Pretoria Magistrates Court claiming arrear rentals from a tenant. And in another court, say, for instance, in the Pretoria High Court, I issue proceedings for an eviction as well as claiming arrear rental. There will be a defense of lis pendens. Lis pendens means there's already pending proceedings on the same subject matter and between the same parties. Then one of the courts, usually the one that issued first, would be the only proceeding that may be pending, or you can withdraw that and then you remove that defense. But in the tribunal, if there are pending proceedings in a court, it's not as simple as withdrawing the proceedings in the court. Simply, the only reply to the tribunal would be, we already have these matters pending under this case number in this court, and the tribunal may not take the matter any further because it's already being adjudicated by a higher entity, being a court. So I've seen this a lot. We start eviction proceedings against the tenant, and then as soon as the sheriff serves the documents on them, they go to the tribunal and say, yeah, but the landlord didn't do maintenance. It's actually a very interesting little trick, but it doesn't work because you're not allowed to do that. So it's a simple reply to the tribunal to say, sorry, Ella, not going to happen. We already have pending proceedings from this date under this case number in this court. And then you will receive, once the tribunal receives your complaint, you will receive written acknowledgement of your complaint. Now, if you don't receive that, guys, please go back to the tribunal, nag them until you get written confirmation of your complaint. Then there will be a preliminary investigation. The staff from the tribunal will look into the matter, see if this actually constitutes an unfair practice. So theoretically, it's at this point where you receive that letter from the tribunal, and this would be the moment where if the fight is actually about your commission, but it now has a bunch of add-on issues, or you completely the wrong party that the complaint is lodged against, this is where you have to reply. Don't wait for a hearing to try and explain what happened. Do a letter and simply say, I am the agent. I am not a party to whatever is happening here. You're barking up the wrong tree. Please go find a better tree to bark up against. Unless, obviously, you acted on behalf of the landlord, then you need to get that to the landlord, because you as the agent can never be the landlord in terms of proceedings in the tribunal unless you had some of the other power of attorney and you signed as the landlord on behalf of the landlord in the lease agreement. Only in those circumstances would an agent be seen as the landlord in proceedings. The rest of the time, you definitely are not. And so just a mandate does not put you in the shoes of the landlord in front of the tribunal. The tribunal may then also instruct an inspector to go and do an inspection on the premises. That would obviously be when there's a dispute, say, around overcrowding or unhealthy or unsafe living conditions, or a lack of maintenance. In those circumstances, the tribunal may send out an inspector to go and investigate and do a preliminary investigation. Jurisdiction means which area and over which matters may the tribunal preside. So it's very area specific. Like I said, if you go on the individual tribunal websites, you would be able to download the unfair practice regulation, and you may contact them and ask, this is the property address, does it fall within your jurisdictional area? And they will say yes or no. The other thing that you need to consider is the matter type. The tribunal, like I said, may only rule on matters that relates to unfair practices exclusively in the context of the Rental Housing Act and the regulations of the Rental Housing Act. Nothing outside of that. Not agent commission, not agent behavior, none of that. Exclusively unfair practices. But they do not, and this I really need to echo a million times. The tribunal does not have jurisdiction to grant eviction orders. Sometimes on non-payment of rent or whatever the situation might be, and there might be a mediation process, and the tenant agrees to vacate on a specific date. That is an agreement. That is not an eviction order. Because that agreement may be made a ruling of the tribunal that may be executed through the magistrate's court. In those very rare circumstances, you might be able to compel a tenant to vacate on a date that he agreed to during the course of mediation in the tribunal. Those are the only circumstances where it might look like an eviction, and it's very often seen in the industry as an eviction, but please know it is not. Only a court may order an eviction. This is in terms of Section 26 of our Constitution, and trust me, the Rental Housing Act or the Rental Housing Tribunal does not have the power to overthrow a provision of our Constitution. The only court that has that power is the Constitutional Court. And the Constitutional Court is our highest authority in the country. The tribunal is a little to a lot below the Constitutional Court. So if the tribunal does something that looks like an eviction, it can only be when it's done on mediation and the parties agree to it. So please don't ever advise your landlord to approach the tribunal for a quasi-eviction instead of approaching a court as we should to obtain an eviction order. Mediation, what does it look like? The Rental Housing Tribunal must determine whether there's a dispute that can be resolved on mediation or not. If it can, if it looks like something that can be mediated on, the tribunal will appoint a mediator, and then it's really a relatively quick and easy process. The respondent will be informed by the tribunal. So the complainant doesn't have to do this. The tribunal will do it. And then the respondent has 21 days, and this is not court days, this is calendar days because it's from the Rental Housing Act, 21 calendar days to respond and or institute a counterclaim. So you tell your story so the tribunal can see what is happening. Then the tribunal must issue a notice of mediation with a date for mediation at least 10 calendar days prior to the date. This is not a trial. It's you simply facilitate conversation. It must be finalized within 30 days from commencement. However, that time period may be extended should both parties agree to extension. The complainant may withdraw his complaint up to 5 days prior to the mediation hearing. I have, however, seen people basically, as they walk in the morning into the tribunal building, they sort of get a little nervous about it, and the complainant says, okay, you know what, actually, I was just upset that day, and let's just let it go. The problem is you might then end up with a cost order from the tribunal. So up to 5 days, you may withdraw without any cost implication towards the other party or the tribunal. If you have legal representation, obviously, by that time, they would have incurred costs. So just be careful of that. On that topic, because mediation is so informal, I would not easily recommend that you get legal representation unless it's a very complex matter, but that will be on a hearing, and in those circumstances, then I would consider legal representation. But for something, just a little bit of a conversation in a mediation, I would not necessarily recommend spending money on an attorney to represent you there. Also, the parties will have to agree to have your legal representation present but it's usually not denied because not everybody is as comfortable with conflict as your typical attorney. If the process was successful, the parties will conclude an agreement, and like I said earlier, that agreement may be made a ruling of the tribunal. If it was unsuccessful, the mediator will issue a certificate stating that it was unsuccessful, and in that particular circumstances, the matter will then go on a hearing. Like I said, if the dispute is of a nature that cannot be resolved on mediation, so you need an expert or evidence or something like that, then we have to go on hearing. If it was unsuccessful, the mediator will issue a certificate to that effect, and then the matter will go on hearing. The tribunal will then issue a summons. Remember, this summons, not all summonses are created equal. Summonses are usually, I sue you for this. This summons will go to all the relevant parties, and it's actually just being summoned to go to the tribunal. That summons must be issued and served in terms of the regulations at least 10 days prior to the hearing. Usually served in person or by attachment, but in most cases, the attempt is to serve on you at home or at your place of business. The respondent, once again, has 21 calendar days to respond to this summons, and either just respond or institute a counterclaim. If the matter then goes on the hearing, the parties, by 5 days prior to the hearing, must exchange all documents that you are going to use. Our legal system, this is the case in all civil proceedings, even criminal proceedings, those spectacular things you see on the movies, where somebody rushes into the courtroom and they say, I found this piece of evidence. It's not real. It's not in our law. It's not in South African law. South African law, you play your cards on the table. Everybody must know all the documentation and all the evidence that you're going to use to prove your case. Not in America, not American law. Unfortunately, there's no TV cameras, and sorry, ladies, I had to break it to you, but I'm not going to run into Harvey Specter at the tribunal. So it's none of that spectacular things. It's actually quite boring, and even in our court system, everybody knows what's going to happen before it happens. So all this information must be exchanged 5 days prior to the hearing. The parties may then meet before the hearing. There's no time limit to this hearing, to this meeting, so you can even meet the morning of the hearing. Now all the cards are on the table. Now maybe the parties can resolve the matter now that they can see where they stand with each other. Both parties have the right to peruse the full file content. So that's exactly what I just said. Nobody surprises nobody with anything. And both parties may see every single piece of evidence or every accusation, every proof, or every witness, everything of the other party. So there's really no surprise. Usually at that point also where there is an opportunity to settle the matter, come to an agreement, and that agreement will then be made a ruling by the tribunal. There must be at least 3 people presiding. This means, so remember, you don't have a magistrate or a judge, you have a presiding officer. So 3 presiding officers in the tribunal. Once again, even the hearings are quite informal. I've only done one appearance in the tribunal. I've done one for a specific reason. After that, I said, no, thank you. It's not the same as a court. And the truth is, I do think it is better in most cases. That there would obviously be exceptions, but for the parties to represent themselves, for the simple reason, it's very real and it's very informal, even in a hearing circumstance. So unless there's something legally technical around the matter, it's actually advisable to represent yourself. The presiding officers must be impartial. They must not ever initiate or consider ex parte communication unless the Act allows for this. This means you can't have one of the parties come to the presiding officer and tell their story without the other party being present. So you can't approach the presiding officers without the other party present. Both parties will be informed of all their rights, and no public person of public that's not relevant to the proceedings or that's been summoned by the tribunal or any of the administrative staff from the tribunal may have any communication with the presiding officers or try to influence the hearing in any way. Process is quite similar to court. When I say that, it's only when you haven't been to an actual court where it would look similar. But you do have the right to state your case. You may bring and present your evidence. You may call witnesses, and you may cross-examine the witnesses that the other party calls. In general, urgent applications and interdicts, urgent applications for interdicts and spoliations are allowed. Those circumstances, the rules are the hearing will be pretty much as soon as possible, and notice of the hearing must be given immediately. In terms of the lockdown regulations under level 3 and currently under level 1 does allow for urgent matters to be heard for spoliation applications to be heard, and that can be done over virtual communication. Once you initiated proceedings in the tribunal, there is a 3-month moratorium on approaching a court. So you may not approach a court unless there is rent or maintenance outstanding. So a tenant may not run to the tribunal when he didn't pay his rent to avoid 3 months eviction. Only where there's an actual dispute and rent is paid on time and maintenance is done, then there's a 3-month moratorium of approaching a court. The tribunal may summon any person that might add value to the hearing, and this is usually where the agent comes in. So an agent will only be required to appear in person where he is mandated to represent the landlord, and for that, that's not part of your normal commission. So then you need to have a specific arrangement with the landlord around your remuneration. Your commission does not compel you to, in normal circumstances, represent the landlord at the tribunal. However, if you are summoned by the tribunal to come and give evidence, not on behalf of the landlord, but with regards to clarification on things between the landlord and the tenant, unfortunately, there you are not entitled to remuneration because you are a witness as in any other court case. When the tribunal summons you to bring documentation with you or to give evidence, that is what I'm talking about, and there you are not entitled to remuneration. However, if there was an incorrect thing where you are now summoned, but actually it's the landlord and the landlord says, no, you go, I anyway don't know what's going on here, once again, have an arrangement with the landlord to pay you if you have to represent him. And obviously, if you are accused of an unfair practice, you might be very relevant in the proceedings, and you might be accused, not in the criminal sense, but together with the landlord. And in those circumstances, you might be, in your personal capacity, have to represent yourself in front of the tribunal. I hope this was as much fun for you as it was for me. There's still a lot of things that I couldn't address simply because we don't have enough time. I want to ask you to go download a copy of the unfair regulations, read through them, and if you still have questions or there's something that's unclear to you, please, please, please feel free to contact us. Let us help you, and let's hope we all stay away from the tribunal unless it's necessary to, for instance, claim a rear rental from a tenant or potentially assist a landlord if there's a dispute about payment of a deposit or something like that. I hope you had a fun March training session, and I really look forward to seeing you all again, either in our question and answer sessions or in the April training session.